Monica, how was lunch? You're muted.
Was good. Was
It
good.
was good? Okay,
Yes, sir.
good.
How was your lunch?
I didn't have time to have any lunch.
I'm sorry. Just because I'm close to this Greek place.
You went to a rib place?
Greek place. Little
Greek
Greek.
place, okay,
It's
good.
like a fast food, but really it's good food, healthy food.
Do you live out in Carrollton also?
It's in Carrollton,
You live in Carrollton?
Plano. Yeah.
Plano, okay, good.
Plano. Carrollton. Line. Yeah.
What?
No siento nada, pero acá me. Pues, qué triste, ¿no? Después que éramos buenos amigos.
Who's the judge?
En fin. Lo malo que fui.
Ms. Waite, yeah, there she is. Very good. Counselor, is everyone ready to proceed?
Yes.
Bench ready?
Ms. Kaffour, you're muted, so I didn't hear you. I saw you saying yes, so I'm gonna.
Your Honor, I'm ready.
All right, I'm gonna recall DC 18-12479. Is there anything that came up during the lunch break that the court needs to address? Hearing none, Mr.
Yes, well, yeah. I think they just filed an affidavit for something for an exhibit, I suppose. I think it's on attorney's fees.
Your Honor, my office filed the bid for my attorney fees. I guess they had not filed it.
And
Okay,
we've got
I'll
an
take a look
exhibit
at it. It's probably is it duplicative of what you testified to, Ms. Kaffour?
Yes, Judge, it's exactly the same thing.
Very good. I'll look at it as we're proceeding as to whether or not anything needs to be done with it. Mr. Clark, you have Ms. New on the stand. Ms. New, let me remind you that you are still under oath, just the same as you were before lunch. So, Mr. Clark, you may proceed.
Judge, and I'll have an exhibit 3 that I also wish to offer.
You have a what?
Exhibit 3 that I'll also that's just come to light.
Okay, has it been presented to the court and to the parties?
I believe
Yes,
we
and I
filed-
received it.
And I forwarded it to you, Judge.
Okay.
And I'm to yell, and Judge, I'm going to ask the court's indulgence, like for 10 seconds, whenever I'm supposed to go yell at my secretary the word exhibits, and she's going to put them on a way that so that the court can see them.
They don't need to be, you don't need, if you'll tell me what exhibit it is, I'll put it on the screen.
Okay. You have exhibit 1, 2, and 3, Judge. Okay.
I
all right.
have your exhibits 1, 2, and 3. Please proceed with your witness.
Ms. New, explain where this business, this chicken business was that was the subject of the investment.
Yeah, was since everything started in 2016. Yeah, I'm sorry. Can you ask the question again? Exactly what you want me to
Yes.
say?
Explain where this chicken business was?
Was in Peru, in Iquitos. Everything is in Peru, nothing here in the United States.
Okay. And was there a time in 2016 that you and Miss Williams went down to,
Objection, lead-in.
well, I haven't finished the question yet.
Agreed.
Okay. Tell us, please explain what you've shown Miss Williams about the chicken business.
We both in 2016 was in Peru since the holidays 2015 to New Year 2016. So we both went to the place, but I didn't approach her for money or nothing. She just looked the place and she was infatuated. Wow, very nice, very cool. I hope I can participate one day like that. Passed the time, and she knew about this one because she was presently there in Peru, in the hometown in Iquitos.
When she said she wanted to participate, what did you take that to?
Later on, but she was so infatuated with everything she saw there. Everybody will
Did it mean that she wanted to raise chickens, or did it mean she wanted to financially
Yeah, but like I mean, invest for growing, because while you invest for certain things, so you're gonna have like a revenue. I forgot, like a winnings, no, in the future.
Okay, a chicken business, that's not an egg business. That's a to serve chickens, to sell the meat, correct?
Yeah, to the community, to the town, or everybody who wants to buy. Normally, it's the restaurants to buy from us, and etc. etc. But this is wasn't.
I'm sorry, ma'am. Wait. I'm having trouble understanding you. Can you, your money is restaurants. I need her to repeat that.
Miss News, slow down when you're talking.
Okay. I say, they repeat everything.
Pretty much, yes, it wouldn't hurt.
Back in 2015, end of the year, to the 16, we both was in Peru. There's a proof of that. So I have this business with my brother-in-law. We raising chickens, like we have like 3 or 4 houses to raise chicken. And because we are friends, normally, no, we're gonna hang around. I have a car there. I drive there.
Hold just a second. When you say we are friends, who are you talking about?
Miss Williams.
Okay. And who is Francisco Villa?
He's my brother-in-law, who is in charge of the chicken in Iquitos with my sister Cynthia.
What's your sister's name?
Cynthia.
And how far is this away from the town where you grew up?
About 45 minutes an hour. The name of the place is Ninarumi. It's hard to pronounce it. Ninarumi is 1 hour away, driving. No highway, just dirt.
Dirt road.
Pero es
tell me about the business. How many chickens are there?
Oh, right now, that right now is not too many, because since we are in the Amazon, always it's, como se dice, overflowing sometimes happening. This is business you risk, no? Because it's close to a big river. Right now we have like probably just 6,000 chickens.
6,000 chickens?
Right.
And this is kind of up the beginning, shall we say, the headwaters of the Amazon area?
Yeah, always. And I have to prove the place is almost next to, because we have to pull the water to feed the chicken. We have to be closer water found, since the big water found.
So the chickens aren't shipped up here to Texas, are they?
Everything was for distribution, for sale in Iquitos, Peru, over Peru. Everything was done in Peru. Nothing here.
Okay. And what was Mr. your brother-in-law? What was he going to do with the investment?
To buy more baby ones, but I know it's kind of late. Baby ones to raise, to grow up. How about the chickens for sale ready? It's about 45 days to raise.
How old is the business?
How long?
How old is your brother-in-law been in this business?
Probably 5 years. 6 years, 5 years, 6 years, between 5, 6 years.
Did Mrs. Williams have a chance to speak to him in Spanish?
I don't, very little, because everything was through me, because he was there when we went to the place, like a normal, no, a trip in our hometown. And she saw the place, and then back after, when we back to United States, she decided to do the investment.
Okay. Did Miss Williams ask you questions about your brother's business?
Yes, she does. She did. She saw with her own eyes. She said, "Oh, I want one day have the same too."
Okay, Judge, I'm going to object to the Miss Williams commenting on the evidence by doing her probably jerking her head around like what she's doing right now. Doing this.
Proceed. She's not testifying right now, Mr. Clark.
My objection is not that she's testifying, Judge. It's that she's making.
Had you not mentioned it, I wouldn't have even noticed it. So
Okay,
please
Judge.
proceed with
I
questioning.
wanted to point it out to the court. Just wanted to point it out to the court. Now, what is were there talk about, what did she say regarding her investing while you were in Peru?
I'm sorry, the question is why?
What did she say about investing in the business while you were in Peru?
Or she didn't mention it in the beginning of the 2016, mention nothing. But when we was here in United States in about end of July, she said, "Can I participate?" 2,000 with 10 grants, $10,000.
Okay.
They say, "Well, I don't know, because those things, you know, it's not like a fact. If we're gonna do this one, I don't want any problems, because this is because everything is friendly, and what I say is informally. I know about the law. I know I'm never gonna do something stupid. It's gonna be against with consequence." So she decided. After 3 months, we have a problem with the flooding. And I say to her, "I guess this one is not gonna go, but oh my God, my money." I was economical good. I decided to return her 9,500 or the 10,000 she gave me.
Okay.
No,
Testimony.
I really didn't have no feel responsible, because she was in her own consent by her, because we all
okay, I'm going to object to my own client. Non-responsive, how you felt responsible is irrelevant. Okay.
Counsel, you can't object to your own client on non-responsiveness.
If they get far enough out, I can't. I thought that is a proposed, the commentators have said, yes, you can, yes, you can't. So in this court, I'll not ever object to my client being non-responsive, no matter how far they get out on a limb, Judge. Okay, so there's testimony that in May of 17, Miss Williams invested $10,000 in cash. Do you recall that testimony? You recall her testifying that in May of 17, she advanced $10,000 in to invest in the business?
Yes, sir.
Remember her saying that?
What?
You remember her saying that?
Yeah, absolutely.
Okay.
because she wanna come back.
How did you get the 10,000 to, or the 9,500 down to Peru?
Because that moment my daughter was going to Peru travel. So I handed to her, I just give 9,500 because you cannot take more than 10,000 by law. You're not allowed cash.
You can take up to 9,500 in cash
Yeah.
or 10,000, up to 10,000?
No, pero she took 9,500 and then I shipped the 500. I mean,
And did you work, what'd you do in the courts? As of what you, about the law and what the regulations on carrying money overseas? What was your connection with the courts in
Peru, I was working directly with the judge as a, ¿cómo se llama? In Spanish, it's say like a secretary, but that also I was paralegals with different law firms. But I've been
okay,
named by the government to be
okay.
a
And
legal
then,
secretary.
okay. The next month in June, 8/17, there's, you recall testimony that there was $10,000 invested, another $10,000 invested by Miss Williams. Do you recall that testimony?
Yes, sir.
Okay. And how did that money get transferred down there?
I traveled to Peru. She gave me in the end of June outside in Papado's restaurant. She gave me in cash. So I went to Peru end of July and I transport that money by my own. Again, do the same system with 9,500. But I'm not considering she gave me the 10,000. Of course, I'm not gonna, no, by law.
Okay. And who did you give the money to? That when you got to Peru, who'd you give the $9,500 to?
But that moment we give ¿cómo se llama? People who was running a campaign because that moment was a campaign time. And she said, what about if we invest in there and see they win? Like they was offer us. If they win, we're gonna have benefits. We can sell our chickens to them in quantity, in huge, and you know how delusional.
Well,
We give us a donation.
How did the politicians have to do with, what did they have to do with the purchase of chickens?
Because like we are friends, so they give us to the distribution to the small towns as a donation. What all the politicians do it, I guess, when they are in campaign, things like
They give chicken out?
that. Chicken out to
Okay.
the restaurants, etc., etc.
Mr. Clark, can we get back to something relevant?
Yeah,
to
sure.
that
Well,
case?
no, what happened to the chicken and why because unless they want to stipulate this investment,
Ms. Alonso.
$20,000, that's fine. But if not, I need to prove up what happened to the money, Judge, and why in the connection with the politicians. If you're instructing
I'm not,
to go down that road any further, I'll be glad to.
what does this case have to do with chickens and politicians in Peru?
The testimony was, and the pleadings of the plaintiff is that this was an investment. The testimony of Ms. Williams was she didn't know what the investment was. That's what she testified.
I don't need to, then prove up either that it was lost or it wasn't returned or it was something other than what Ms. Williams testified to. You're telling me a bunch of stuff that cannot fit into a judgment here and is therefore
Right.
irrelevant to this action.
Okay. Ms. New, what happens, and what was done with the money that your daughter transferred down the month before?
I had to give it to my brother-in-law, Francisco Del.
And what happened to the business? Did it lose money?
He buys the baby chickens because when they're babies, take 45 days to grow. So we need the food, the money is for everything. It's not just what's her, what's my too, everything together.
Okay, now, some of the, how much of the investment of the $20,000 investment was returned to Mrs. Williams?
How much that I believe it, Naita is the totally the 20,000 is 19,500.
Okay,
While I have in documents like I provide with the exhibition.
we'll go back, okay. On October 6th of 17, there was did you repay some money? When I say repay, did you, I want to use a neutral term, transfer money, $500? Where did you transfer $5,500 on October 6th of 17?
Was a deposit check in the October, the 6th of October, the 17th. Was a check from Chase Bank to her account, Chase Bank.
Okay. Do you have that account? Do you have that check? Because I don't see that.
Yes.
Did you give it to her in cash?
No, you gave her cash? No, it was check. You don't have the copy
Okay.
of the check? We have a big time.
No, I did not. Okay, and then on November 10th or 11th, how much did you transfer to her?
November?
Of 17, 10th or 11th?
I'm confused. The 10th, 11th, I'm going.
Okay, I'm going to start over, but this will be the last time we're going to go over this.
Yes, sir.
I will. The other lawyer may go over it again. On October 6th, how much did you transfer to Ms. Williams?
Okay, in October 6th was 5,500. I deposit in her account, Chase by Chase.
Deposit in her account. Did you write a check?
Yes,
Or did
sir.
you put cash in her account?
No, check. It's a check.
Okay, you have that check there, because I do not.
Mr. Clark, it's plaintiff's exhibit number 1. Please proceed.
I'm sorry, it's not, Judge. I hate to contradict you, but that's 2016. That's a different
Oh, no,
year.
this is. I'm
No,
sorry,
plaintiff's exhibit number 1 is a check
not us.
dated October 6, 2017 in the amount of $5,500. There's been testimony about it. It's been admitted into
Oh,
evidence.
plaintiff's number 1. Okay, gotcha. Okay, I apologize, Judge. Okay, I was looking at my exhibits. Okay, and then what about what happened on November 10th or 11th of 2017?
Oh, I give her cash, 4,000 cash, and what she admitted before, you know, in the law case, and the suit.
Okay,
I'm sorry, you're cutting out really bad. I didn't get the last part of that.
Oh, I say I give her the 4,000 cash in a restaurant, Incas Cafe, in cash. What the witness I was my daughter, and I guess Miss Williams admitted I give it in the petition.
okay. And then what about on December 20th?
Oh, I
Oh.
give her the 2017, I give her a check for $2,000. It was a check too.
Okay,
Bank to Chase Bank. Not transfer it directly. Just give her a check.
okay, and a direct. And then on 12/26, what happened?
she mentioned it, the money was from her and her husband together. She told me, you need to put $4,000 in my husband account, and I did, and I proved with the voucher that it's an exhibition, number 3 or 4. I did.
Okay. Judge, and you recognize that I would offer defendant's exhibit 2 at this point. Did you pull that up, Judge?
I've got it. Defendant's exhibit number 2 is a what appears to be a Bank of America deposit receipt dated 12/26/2017.
Was transferred.
Ms. Kafour, any objection to defendant's exhibit number 2?
Your Honor, I'm so sorry. I'm trying to pull it here. I don't see it on the screen, but I'll pull it on my
Let me
email.
share screen.
Your Honor, I object to this exhibit. There's nothing in here that mentions my client's husband. There is no way to identify this account as my client's husband's account. And so I object, Your Honor. It's not properly proven. The authenticity of it is not properly for you to admit this as an evidence.
All right, I view that as going to the weight, not the admissibility. I'll admit defendant's exhibit number 2.
And by the way, you were given the information, his checking account ended in 9335, her husband's did. I'm asking you, Miss New.
Yes.
Were you told her husband's account ended 9335?
Yes. I transferred from my checking account to here directly.
Okay. And
See.
in August, did you deposit or was there a $500 transaction provided?
Yeah, was in August. I gave because she was asking me, can you give me, please put 500 in August, I believe, to him, and another one in September. But I don't have a voucher to prove because.
Wait, you put it in his account?
Yes, sir. I did.
Okay. And then what about in September? Were there any transactions in September?
The same. I did the same thing because she asked me to do it. She
And
mentioned both.
And in September, was there also a $1,000 transaction?
No, the 1,000 was cash.
And who did you give that to?
Carla Williams, or Miss Williams,
Okay.
excuse me.
So there's, let me ask you. Is it come out to 19,500
Yes, sir, kind of like that.
for the investments? Okay, and this was a return on the investments?
Yeah, because really, I don't want to feel like I have to pay nothing back there.
Well, hold it, but I didn't ask that.
Okay.
I'm not allowed to say non-responsive to my own client in this court. Okay, but I'm trying to rein in my client, Judge, to move this along.
Judge, Mr. Clark, ask good questions and you'll get good answers.
Okay. Well, now,
I talk too much.
how's the chicken business coming along now?
Really kind of stable, but that time in 2018, right now it's stable, but 2018 was.
Okay, Now,
No good.
have you read, did you ever agree to pay 10% per month
No,
on the investment?
not at all. We didn't talk nothing about that. She was saying if it's good, maybe I say no, no agreement or nothing, everything friendly. Just like I say,
Okay. And the plaintiff's petition, if it, tell me, does it claim that there was an that this money was invested?
the client was invaded verbally, yes, but verbally, nothing like I repeat,
Okay, I'm not going to ask you what the petition says. The judge can read the facts. And okay, I'll pass the witness.
Ms. Kafour, you're a witness.
Thank you, Judge. Ms. New, did you bring anything to this court to show the judge some of these investments that you're talking about? The chicken, the political investment? Do you have any paperwork to show this judge what type of investments you had in Peru?
I don't have it in it because everything was done in Peru. Since I cannot bring the chicken farm to here, but I have a pictures.
Isn't it true that you recently went to Peru, so you could have gotten those documents from Peru?
The documents is because I repeat, I extremely repeat, was friendly done by her own choice, approach me, she wanna do that.
Unresponsive, I object, Your Honor, unresponsive.
Sustained.
Ms. New, we had trials set a few months ago. Actually, last year, you asked this court to reset it because you were in Peru. Isn't that correct?
Yes, that's correct. I was in Peru, went to Peru.
Okay. And while you were in Peru, knowing that this case was coming up, did you bring copies of the paperwork to prove this business that you had in Peru?
Objection, Judge. It's irrelevant. And she's already asked, it's cumulative. She said, did you get any documents? She says she's got a photo of it. There's uncontested evidence that the woman went down and looked at it. Their own pleadings say that. And so this question of, did you go down when you were in, we'll stipulate she went to, every time we said in pleadings that she was.
State an objection, not an argument.
Right. Well, okay. Judge, I think it's irrelevant whether or not, and it's also been asked and answered as to whether she got any, the investment information down.
Sustained on the asked and answered, and frankly, it bears nothing on my decision. So
Okay.
Excuse me, sir, can I have a question? My battery is going 2%. Can I go to my car, plug together with my computer in my hand? I'm not gonna leave the room.
for what reason?
Because I'm in a park, I can see it's 2%, but I can plug in my car the computer so we continue. Can I please? Sorry.
We'll
She's
go
about
on
to lose the
recess
signal,
for
Judge.
2 minutes.
Sorry.
I didn't know my client had such a nice home, but
All
apparently.
right.
Are.
While she's doing that,
Beautiful, there will be so many.
Mr. Clark, Ms. Kafour,
Yes, Your Honor.
this has gone way beyond this case. Court's heard the testimony. Let's wrap this up.
I pass this witness, Your Honor. I rest.
Yeah.
Judge, I would like to call Jennifer, Stephanie, recall her just for the purpose that she took $9,500 down to Peru when of the first 10,000.
Your Honor, may I speak?
I could care less if she took $9,500 down to Peru. So it's
Okay.
Again, it's not relevant to the decision making here.
Okay. Then I rest.
Ms. Kafour?
Yes, Your Honor, I rest, Your Honor.
All right. Then let's take a 5-minute break, let Ms. New get reset, and then come back for succinct 5-minute arguments. Does that sound like a way to proceed here?
Yes, Your Honor.
I think so
Very good.
too, Judge, and I'll have a timer on.
All right, very good.
I'll have my clock, my watch out.
We're in recess for 5 minutes. Return at 2:10 p.m.
Thank you.
I'm sorry. I switched to my phone.
That's okay. We're just on a little bitty break. We're starting back in a couple of minutes.
Okay. I'm sorry. Can you repeat again, please?
We're on a break, Monica.
Oh, okay. Oh, I'm
I
sorry.
think we come back in 2 minutes.
Okay, sir. Tengo calor. It's so hot. Más tranquilos. Pero porque la agarran. Ya va a acabar. Sí.
una hoja que salga de la computadora. No pensé que iba a ser. Ay, sí, todavía seguimos. Oh, de este. Sí, hasta la siguiente. No sabes.
Mr. Clark, are you ready?
Oops.
Ms. New,
Yes.
just for what it's worth, while you were transferring to a different computer, in essence, you were passed as a witness, meaning they were done with their questioning for you, and both sides have rested.
Yes, sir.
So we are back on the record on DC 18-12479. We're at closing arguments. Ms. Kafour, please let me hear your argument on this case.
Okay, thank you, Your Honor. Your Honor, again, this is a case about trust. While naive and not wise, my client believed in her friend and wanted to grow her money because her friend promised that she could grow her money for her if she could just hold on to this funds. My client gave the first amount of money, $2,000, received her interest. That was encouraging to her. She invested the second amount, $4,000, received another $400. Then she invested another $10,000, and Miss New paid her out the interest, which is the 10% they agreed, $1,600. And this motivated my client to continue again. While naive, unwise, she took her son's funds that she saved all her life. And she gave her friend $30,000, hoping that she would receive the $3,000 back from her friend. Your Honor, this case is about trust and a friendship that has failed because of a broken trust. Ms. New has had a couple of trips to Peru. If there was truly any business investment that she discussed with Ms. Carla Williams, she would have had the opportunity to gather all the records with all the funds that were sent to Peru, gather all the records for all of the investments with the political or the chicken, and she would have brought it to court because it's important for the court to see this investment that she says she had Ms. Williams a part of. She didn't bring any record to the court because there was absolutely no investment plan. She had this money. She wanted to deceive her friend, and she did. She succeeded in deceiving her friend. And we're here today because Ms. New should be held accountable. She took advantage of her friend, Carla Williams, who is naive, and she played on her intelligence on the small amounts, 200, 400, 10,000, and after the 30,000, she disappeared. Ms. New knew she was wrong, and that's the reason why she went up to the attorney's office to try to resolve this matter. In fact, she claims this was an investment. She would not do that. She went up to the attorney's office in an attempt to resolve the issue, and then decided that she was going to hire counsel to get away from this issue. And I plead with the court not to allow Ms. New get away with this issue. She took money from her friend. There was not an investment plan. Her friend gave her money, and she should be made to return the funds that she took from Ms. Carla Williams. And that's what we're pleading with this court. In addition to that, Ms. Williams had to hire me to do this case, Your Honor. We're asking that you order that Ms. New pay back attorney fees in this case. There's not been any dispute as to how much. She has not disputed the $30,000 that Ms. Carla Williams gave her. She hasn't disputed the $10,000 Ms. Carla Williams said she gave her. There's no dispute as to the $2,000 or the $4,000. The only thing that she's done with the court today is tell us about an additional $10,000 that was given to her prior to this incident in 2016. She claims she has returned that $9,500 to my client. My client's not here for that case. My client's here specifically for the case that started when she handed Miss New the first $2,000 from April 1st all the way to June, when she handed the last amount of money of $30,000. And we're begging this court to hold Miss New accountable, have Miss New refund this money, and make her stop this thing that she's doing all around her community.
Mr. Clark,
Or have they used their 5 minutes?
got about 30 seconds left. I'll give her a minute for rebuttal, please.
Okay. Judge, there was no 30,000. There was only 2 payments of 10,000. One on May 22, both in May of 2017. Anyone can come and say, well, you gave me all this cash, all the big amounts under their Ms. Kapor's argument is all not supported by other than the plaintiff who has the burden of proof is trying to say that they gave all this money. They didn't even get a receipt on the back of an envelope. Their argument is inconsistent because they're saying there was money that was advanced. I think they've claimed 30,000. So you had 10,000 and 10,000 paid in 2017, invested in. The testimony is August, 100 deposited, 500 in September of 2017, and $1,000 cash in October. Then October 6th, there was $5,500 check to Miss Williams. November 11th, 2,000. December 20th, 2,000. December 26th, 2,000 and 4,000. That's the testimony. Now, anyone can come up and say you've paid me money. They question whether it's an investment. 3 or 4 problems. They could have called their client back and said, no, I didn't go down and look at this property that you were going to put in the chicken ranch. I didn't do this. They say, you've got all this time. We wouldn't have spent the time. It was handed to the brother to invest in the ranch. She knew, she had been to the location and knew about the business. So we could send Miss Kafor down to Peru to investigate, and she wouldn't find, there's nothing that other than the deposit slips from her brother, which was never put up in this matter. As far as attorneys, I'll just dismiss this, Judge, under the recent Rumas Venture case from the Texas Supreme Court of 2019. I can give you the site. It's 62 Texas Supreme Court Journal 808. And in it says it has to be, it cites from other Supreme Court cases going back.
I'm well aware of the Rumas Ventures case.
Okay, and it has 5 different, they've got to put a required for each services, perform those services. This didn't do that. In El Apple, this testimony that you heard from Ms. Kafor is not evidence. It's not even evidence. I didn't object to it because it's not evidence. And I can get you the site out of El Apple. All these cases are the project. I realize the Dallas Court of Appeals was very reluctant to follow that, and very reluctant, had to be reversed out of this by the Supreme Court on this issue. Again, their own pleadings, they're stopped from denying that this was an investment, and they put it in their pleadings. Now they're trying to make it was an unpaid loan. It's not, and they have the burden here. You had she says, she says is basically in this case. There is no proof or even credible evidence that there was anything more than a dispute between two good friends. And the reason we wanted to get into sisters, there may be people fudge with sisters, and there's disputes, and there's all kinds of different issues going on. And as far as the attorney, I know the court raised the attorney-client privilege, didn't allow me to go into what was said there. Judge, if Miss Williams and Miss New were both there, there was no attorney-client privilege. That was not. It's only when you talk to your lawyer without other people, non-parties being there, is the only time or I would have gone into what the prior lawyer, and the prior lawyer did withdraw. So based on that, Judge, I believe there should be a take nothing in this case.
Are you suggesting, Mr. Clark, that the $30,000 was never paid by Ms. Williams to Ms. New?
Yes, I am. And I would like permission to reopen if they have a question about it.
Fair. I understand that's your position. Very good. That's all I needed to know. Ms. Kafour?
Your Honor, my client was on the stand, and several times she said,
1 minute.
yes, she gave money. She gave money and she got money back. And that's a form of investment. But what she clearly told the court is they never discussed any particular investment. What she wanted to do was to get an increase in her money, which is she gives it to her friend, gives
I'm
it
sorry,
back
you're
to her.
cutting out. Ma'am, you're cutting out what she wanted to do, and then
You cut out.
Okay, what she wanted to do was to get an increase in her money by giving it to Miss New. There was no specific investment. She wanted to get her money, but the plan was to get her money back after a period of time, but in the interim, get her 10% interest every single month. The math that counsel and his client has brought to the court is really inconsistent with what they're saying. They have 5,500, 3,500, 2,000. They have another 4,000. Then they have another 9,500. It's not what they're presenting to the court. And I would say that they're here to mislead the judge. The specific facts in this case is that they have paid back.
Your Honor, I'm going to object. I'm going to object.
On what basis?
Court's ruling on timing. It's 1.5 minutes they've used.
Ms. Kafour, I've heard everything I need on that.
Thank you, Your Honor.
Let's go recess for 3 minutes. I'll be back and I'll announce a judgment on this case.
Thank you.
Thank you.
La única razón.
Mr. Clark, are you ready?
Mr. Clark.
Okay. The court is unclear whether or not this was an investment or a loan or what the exact nature of the payment was, other than certainty that it wasn't a gift. The evidence is relatively clear that $46,000 even was provided by Ms. Williams to Ms. New. Recognizing that there is some dispute as to that, the court is persuaded by plaintiff's exhibit number 3 that is the amount. For what it's worth, defendant has defendant's exhibit number 3, which was never offered and therefore never admitted, but it even included the same signature line that was on plaintiff's exhibit number 3, which convinces the court that the amount that was provided by Ms. Williams to Ms. New was $46,000. The court finds that $15,900 of that was returned, leaving a balance due of $30,100. Court will enter judgment for plaintiff in the amount of $30,100. In addition, the court finds that following the Roarmore's ventures, that 21 hours of attorney's fees have been established as being necessarily incurred and reasonably incurred, and that a $300 attorney's fee for those hours is reasonable. That would support $6,300 in attorney's fees. Only $6,000 was asked for, so the court will render judgment in the amount of $6,000 in attorney's fees. Ms. Kafour, will you please present a judgment in those amounts? Run it by Mr. Clark as to form.
Yes, Your Honor. Thank you, Judge.
Yes, yes,
You're welcome.
And
Is
we'll be
there-
requesting findings of fact, conclusions of law.
You are absolutely, please, if you have findings of fact and conclusions of law, please present them.
Thank you, Your Honor.
You are, and the court will timely respond with findings of fact and conclusions of law.
Thank you, Your Honor. Nice to
Thank
meet you.
you.
Thank you.
It would be
Anything
excused,
further?
Your Honor. Nothing, Your Honor.
All right. Oh, Mr. Clark disappeared. Very good. Then we're adjourned.
Thank you, Judge.
Thank you.
Ramen. Ahí está acabado.